Welcome back to Financial Literacy for Lawyers, Bridging Law and Business. I'm Professor Seth C. Oranburg, and today's episode explores how financial analysis and legal insight intersect in the world of mergers and acquisition. This is where deal structure, financial statement, and risk management truly come together. So, whether you advise buyers or sellers or boards, a basic grasp of M&A deal structure is now essential for legal professionals. We'll decode it like a complex contract, showing how the numbers we've learned to read, from the balance sheet snapshot to the income statement movie to the cash flow behind the scenes, shape every clause and contingency. If you're connecting this to board duties from episode 7, you're on track. Deals are where oversight meets action. There's no need to be an M&A specialist. We're going to focus on fundamentals. And as a reminder, this podcast is for educational purposes only. For specific legal advice, consult a professional. Every merger or acquisition revolves around a binding agreement that lays out the rights, obligations, payment methods, financing, and risk allocation in the deal. There are three common merger and acquisition structures. One is an asset purchase, where a buyer is going to purchase assets but not liabilities. And one of the major risks is that if you leave too many liabilities behind, there could be a fraudulent conveyance of the assets. Another is going to be a merger, where you have two companies that become one through a statutory process. And the third is a stock purchase, which is acquiring some or all of the ownership shares and absorbing some or all of the company, which would include both its assets and liabilities. Deal structure determines many things, including post-closing tax liability. For example, asset deals allow step-up basis for depreciation. Mergers and stock deals result in exposure to legal risks like unknown claims afterwards. Core terms negotiated should include purchase price and payment terms, cash for certainty, stock for shared upside, or a mix. There could be financing agreements like bank loans, and there can be leveraged buyouts and sales, or seller notes for deferred payment. There can also be earnouts, which are additional payments tied to future performance, like hitting revenue targets. There are often indemnity provisions, which covers who deals with post-deal losses. And there can be all sorts of caps and baskets, which determine when people get paid based on what events happen. Of course, there's also regulatory matters like post-filing and antitrust approval and due diligence contingencies. A well-structured M&A deal protects clients from surprises and ensures value creation. For example, in an asset purchase agreement, buyers can cherry-pick to avoid legacy lawsuits. But again, if there are too many liabilities in the company that's left as a shell, we could have a risk of fraudulent conveyance. So once again, even an M&A lawyer needs to have a good understanding of the financials, ensuring that the structure matches the numbers for better business outcomes. Financials drive deals. Legal and financial due diligence is central to a successful deal. This involves combing through the target's balance sheet for solvency, assets versus liabilities, and hidden liabilities like off-balance sheet items, looking at the income statement and cash flow for sustainable earnings, whether growth is real or inflated, continuing to determine if there is real liquidity, reviewing the footnotes for pending litigation, tax risks, or uncollected revenue that could all erode value post-closing. Key metrics would include revenue trends. Are they steady or volatile? Profit margins, like gross as a percentage of sales to determine the efficiency of the company. EBITDA, which means earnings before interest, taxes, depreciation, and amortization, which tells you about operating performance. Cash flow consistency, and debt levels. All this would guide pricing and terms, and all of these would also be benchmarked against industry standards. Now, it's typically not the lawyer's job to run all these numbers. There's typically a banker involved who's going to determine how these numbers result in the value of a company. But it's very important for the lawyer who's involved to at least understand what's going on, because discrepancies are red flags such as inconsistent revenue recognition, booking sales too early, contingent liabilities, potential lawsuits, or off-balance sheets debt could delay or derail the deal. and it may mean that the lawyer should insist on certain protections and provisions in the contract. For example, if operating cash is negative despite positive earnings, that signals potential manipulation, which would require probing deeper into sustainability. And if you can't get the answer, you might ask for some representations and warranties from the seller. Why care? Because financials inform structure. High leverage might favor a stock deal to assume debt smoothly without refinancing, while lumpy revenue could push for earnouts to tie to payments because you don't know what the actual results will be, and that leaves the risk with the company who's selling and knows better about why their revenue is lumpy. In the failed Microsoft TikTok talks of 2020, regulatory and financial uncertainty from cash flow protections amid national security reviews killed momentum, which highlights how numbers drive decisions beyond price. As a lawyer, a huge part of your job is to allocate risks through the deal documents. Deal documents, whether a merger agreement, asset purchase agreement, or stock purchase agreement, typically include representations and warranties, which will have assertions about financials, assets, and compliance. The purpose is to assure accuracy in the numbers and to have promises that operate in the ordinary course until closing, preventing value destruction, and creating indemnification that allocates responsibility for post-closing issues like breaches and closing or termination conditions like approvals or what allows for a walkaway, and are there breakup fees for failed deals. Legal professionals must assess not just disclosure accuracy, but how protections respond if problems arise. Indemnification, for example, might cover losses from misrepresented financials with deductibles, baskets before claims kick in. There also might be a material adverse effect or MAE clause, which would let a buyer exit if major changes occur. These should be defined tightly to avoid abuse, and they often exclude general economic shifts. So here are some red flags in allocation. Vague representations on earnings, quality, or undisclosed debts can lead to disputes. In Acorn versus Frenesius 2018, Delaware courts allowed a buyer to terminate over a MAE clause where financial declines and covenant breaches occurred, which set precedents for tying clauses to metrics like EBITDA drops. The case involved the buyer backing out of a $4.3 billion acquisition after the seller's business deteriorated post-signing, with the court finding that a 20% EBITDA drop qualified as a material adverse event. It was a rare buyer's win in Delaware. Let's move to tax financing and strategy. Asset versus stock deals shift taxes and liabilities. Asset purchases let buyers step up basis for tax benefits. They have higher depreciation deductions, but they may trigger seller taxes on gains. Stock deals mean that the buyer inherits everything. So they're simple and they avoid asset by asset transfers, but they have their own set of risks. Risk can also come from how the deal is financed. All cash is clean, but it ties up capital, while debt finance amps leverage, raising insolvency odds if projections falter or rates raise. And stock and equity mixed deals take in market risk. Strategic fit, the why, like synergies, cost savings from combined ops, or market expansion, have to align with financials to avoid post-closing surprises. There's some high-profile flops that illustrate this point. The AOL-Time Warner merger in 2000 failed due to overstated synergies, leading to $98 billion in write-downs and huge lawsuits over the failure of that integration. The $106 billion deal, the largest at the time, collapsed amid dot-com bust and culture clashes, resulting in Time Warner spinning off AOL in 2009 after massive losses. More recently, UBS's 2023 acquisition of Credit Suisse involved absorbing massive debts, with cash flow strains from deposit outflows prompting regulatory bailouts and ongoing litigation over reporting controls, including U.S. investor suits that are continuing as of the time I'm recording. The $3.2 billion deal, forced by Swiss authorities to prevent collapse, led to UBS facing lawsuits alleging Credit Suisse defrauded investors by hiding risk before the merger, with a New York judge in July 2025 denying UBS's motion to dismiss. These show that ignoring tax and financing is a way to make a deal crumble. Due diligence must validate the strategic narrative with hard numbers. Here are steps to weave financials into M&A. Now, of course, this isn't a whole class on the topic, but just a few ideas. The first is to integrate financial and legal teams early, because you want to ensure that data and terms align. Although it's often that the M&A drafting team is siloed from the finance team, this is a mistake. Use quality of earnings reports beyond audits to verify adjusted metrics and have conversations early on about whether the merger documents need to incorporate various protections because of issues with the financials. The second is to insist on full access to accounting records, contracts, and data rooms. Run pro forma ratios post deal to forecast combined financials. If a company is hesitant to give up its financials, that's a really clear red flag. The third is to use clear, specific language in documents to allocate risk, like tying earnouts to defined EBITDA with anti sandbagging clauses, preventing buyers from claiming known issues post close. A fourth is to anticipate disputes, embed arbitration for efficiency, have indemnity caps to limit exposure, and you can use holdbacks and other withheld price portions if there are concerns about how the future will play out. You may not get that agreement from your counterparty, but it's worth discussing. You'll also want to define material adverse effect with objective metrics like drops in EBITDA to reduce ambiguity. And the fifth is for red flags like manipulated revenue or undisclosed litigation to be surfaced by a careful look at, once again, all three of the financial statements. There's obviously a lot more to mergers and acquisitions than what we could cover today, but what I hope I got across was that you want to view these M&A deals through financial eyes to bridge law and business. A siloed approach is going to create risk. In our next episode, we're going to talk about how this also applies to securities regulation and securities practice. But until then, I'm Professor Seth C. Orenberg, and this has been Organized.